The Second Amendment, right to bear arms, passed by Congress September the 25th, 1789, ratified December the 15th, 1791. The first 10 amendments form the Bill of Rights. A well-regulated militia being necessary to the security of a free state, the right of the people to keep the bear arms shall not be infringed. Comment petition by Nelson Lund and Adam Winkler. Modern debates about the Second Amendment have focused on whether it protects the private right of individuals to keep the bear arms, or the right that it can be exercised only through militia organizations like the National Guard. This question, however, was not even raised until long after the Bill of Rights was adopted. Many in the founding generation believed that the governments are prone to use the soldier to oppress the people. English history suggests that this risk could be controlled by permitting the government to raise armies consisting of full-time paid troops only when needed to fight foreign adversaries. For other purposes such as responding to sudden invasions or other emergencies, the government could rely on the militia that consist of ordinary civilians who supply their own weapons and receive some part-time, unpaid military training. The onset of war does not always allow time to raise the trained army, and the Revolutionary War shows that the militia forces could not be relied on for national defense. The Constitutional Convention, therefore, decided that the federal government should have almost unfettered authority to establish peacetime standing armies and regulate the militia. This massive shift of power from the state to the federal government generated one of the chief objections to the proposed constitution. And the Federalists argued that the proposed constitution would take from the states their principal means of defense against the federal usurpation. The Federalists responded that the fear federal oppression were overblown, in part because the American people were armed and it would be almost impossible to subdue through military force. Implicit in the debate between Federalists and Anti-Federalists were two shared assumptions. First, that the proposed new constitution gave the federal government almost a total legal authority over the army and militia. Second, that the federal government should not have any authority at all to disarm the citizenry. They disagreed only about whether armed populace could adequately deter federal oppression. The Second Amendment conceded nothing to the Anti-Federalist desire to sharply curtail the military power of the federal government, which would have required substantial changes in the original constitution. Yet the amendment was easily accepted because of a widespread agreement that the federal government shall not have the power to infringe the right of the people to keep the bear arms. Any more than it should have the power to abridge the freedom of speech or prohibit the free exercise for religion. Much has changed since 1791. The traditional militia fell into destitute, and the state-based militia organizations were eventually incorporated into the federal military structure. The nation's military establishment has become enormously more powerful than 18th century armies. We still hear political rhetoric about federal tyranny, but most Americans do not fear the nation's armed forces, and virtually no one thinks that an armed populace could defeat those forces in battle. Furthermore, 18th century civilians routinely kept at home the very same weapons they would need if called to service in the militia, while modern soldiers are equipped with weapons that differ significantly from those generally thought appropriate for civilian uses. Civilians no longer expect to use their household weapons for militia duty, although they still keep and bear arms to defend against common criminals, as well as for hunting and other forms of recreation. The law has also changed. While states in the founding era regulated guns, blacks often prohibited from possessing firearms and militia weapons were frequently registered on government rolls. Gun laws today are more extensive and controversial. Another important legal development was the adoption of the 14th Amendment. The Second Amendment originally applied only to the federal government, leaving the states to regulate weapons as they saw fit, although there is substantial evidence that the privileges or immunities clause for the 14th Amendment was meant to protect the right of individuals to keep and bear arms from infringement by the states. The Supreme Court rejected this interpretation, United States versus Crenshaw, 1876. Until recently, the judiciary treated the Second Amendment almost as a dead letter. In the District of Columbia versus Heller, 2008, however, the Supreme Court invalidated federal law that forbade nearly all civilians from possessing handguns in the nation's capital. A 5-4 majority ruled that the language and history of the Second Amendment show that it protects the private right of individuals to have arms for their own defense, not the right of the states to maintain a militia. The dissenters disagreed. They conclude that the Second Amendment protects a nominally individual right, the one that protects only the right of the people of each of the several states to maintain a well-regulated militia. They also argued that even if the Second Amendment did protect an individual right to have arms for self-defense, it should not be interpreted to allow the government to ban handguns in high-crime urban areas. 2 years later, in McDonough versus the City of Chicago, 2010, the court struck down a similar handgun ban at the state level, again by a 5-4 vote. 4 justices rely on judicial precedents under the 14th Amendment's due process clause. Justice Thomas rejects those precedents in favor of reliance on the privileges or immunity clause, but all 5 members of the majority concluded that the 14th Amendment protects against state infringement to the same individual rights that is protected from federal infringement by the Second Amendment. Notwithstanding the lengthy opinions in Heller and McDonough, they technically ruled only that the government may not ban the possession of handguns by civilians in their homes. Heller tentatively suggests a list of presumptively lawful regulations, including bans on the possession of firearms by felons and the mentally ill, bans on carrying firearms in sensitive places such as schools and government buildings, laws restricting the commercial sale of arms, bans on the concealed carry of arms, and ban on weapons not typically possessed by law-abiding citizens for lawful purposes. Many issues remain open. The lower courts have disagreed with one another about some of them, including important questions involving restrictions on carrying weapons in public. Matters debate. First perspective, not the second-class right. The Second Amendment today by Nielsen Lund. The right to keep and bear arms is a lot like the right to freedom of speech. In each case, the Constitution expressly protects a liberty that it needs to be insulated from the ordinary political process. Neither right, however, is absolute. The First Amendment, for example, has never protected perjury, fraud, or countless other crimes that are committed through the use of a speech. Similarly, no reasonable person could believe that a violent criminal should have unrestricted access to guns, or that any individual should possess a nuclear weapon. Inevitably, courts must draw lines allowing government to carry out its duty to preserve an orderly society without unduly infringing the legitimate interests of individuals in expressing the thoughts of protecting themselves from criminal violence. It's not precise science or one that will ever be free from controversy. One judicial approach, however, should be unequivocally rejected. During the 19th century, courts routinely refused to invalidate restrictions on free speech that struck the judges as reasonable. This meant that speech got virtually no judicial protection. Government suppression of speech can usually be sought to serve some reasonable purposes, such as reducing social discord or promoting healthy morals. Similarly, most gun control law can be viewed as an effort to save lives and prevent crime, which are perfectly reasonable goals. If that is enough to justify infringements on individual liberty, neither constitutional guarantee means much of anything. During the 20th century, the Supreme Court finally started taking the First Amendment seriously. Today, individual freedom is generally protected unless the government can make a strong case that it has a real need to suppress speech or expressive conduct, and that its regulations are tailored to that need. The legal doctrine has become quite complex, and there is room for disagreement about many of the court's specific decisions. Taken as a whole, however, this body for case law shows that what the court can do when it appropriates value for individual rights enshrined in its constitution. The Second Amendment also raises issues about which reasonable people can disagree. But if the Supreme Court takes these provisions of the Constitution as seriously as it now takes the First Amendment, which it should do, there will be some easy issues as well. District of Columbia versus Heller 2008 is one example. The right of the people protected by the Second Amendment is an individual right, just like the rights of the people protected by the First and the Fourth Amendment. The Constitution does not say that the Second Amendment protects the right of the states or the right of the militia, and nobody offers such interpretation during the founding era. But the historical evidence indicates abandoning historical evidence indicates that the Second Amendment was meant to leave citizens with the ability to defend themselves against unlawful violence. Such threats might come from usurpers, governmental power, but they might also come from criminals whom the government is unwilling or unable to control. McDonald versus City of Chicago 2010 was also an easy case on the court's precedents. Most other provisions of the Bill of Rights and are already being applied to the state because they are deeply rooted in the nation's history and tradition. The right to keep and bear arms clearly met this test. The text of the Constitution expressly guarantees the right to bear arms, not just the right to keep them. The court should invalidate regulations that prevent law-abiding citizens from carrying weapons in public, where the vast majority of the violent crimes occur. First Amendment rights are not confined to the home, and neither are those protected by the Second Amendment. Nor should the government be allowed to create burdensome bureaucratic obstacles designed to frustrate the exercise of Second Amendment rights. The courts are vigilant in preventing government from invading the First Amendment through regulations that indirectly abridge free speech rights by making them difficult to exercise. Courts should exercise the same vigilance in protecting Second Amendment rights. Some other regulations that may appear innocuous should be struck down because they are little more than political stunts. Popular bans on so-called assault rifle, for example, define these class guns in terms of cosmetic features, leaving a functionally identical semi-automatic rifles to circulate freely. This is unconstitutional for the same reason that it would violate the First Amendment to ban words that have French etymology, or to require that French fries be called freedom fries. In most American states, including many with large urban population centers, responsible adults have easy access to ordinary firearms, and they are permitted to carry them in public. Experience has shown that these policies do not lead to increased level of violence. Criminals pay no more attention to gun control regulations than they do to laws against murder, rape, and robbery. Armed citizens, however, prevent countless crimes that have saved many lives. What's more, the most vulnerable people, including women, the elderly, and those who live in high-crime neighborhoods, are among the greatest beneficiaries of the Second Amendment. If the courts require the remaining jurisdictions to stop infringing on the Constitution's right to keep and bear arms, their citizens will be more free and probably safer as well. Okay. The second perspective, The Reasonable Right to Bear Arms by Adam Winkler. Gun control is as much a part of the Second Amendment as the right to keep and bear arms. The text of the amendment, which refers to a well-regulated militia, suggests as such. As McCord correctly noted in his District Columbia v. Heller, 2008, the militia is a founding era with a body of ordinary citizens capable of taking up arms to defend the nation, while as the founders sought to protect the citizenry from being disarmed entirely, they did not wish to prevent the government from adopting reasonable regulations of guns to the gun owners. Although Americans today often think that gun control is a modern invention, the founding era has a law regulating the arms citizenry. There were laws designed to ensure effective militia, such as laws requiring armed citizens to appear and mandatory musters where their guns would be inspected. Governments also compiled registries of civilian-owned guns appropriate for militia service, sometimes conducting door-to-door service. Founders has broad bans on gun possession by people deemed untrustworthy, including slaves and loyalists. The founders even had laws requiring people to have guns appropriate for militia service. The wide range of founding era laws says that the founders understood gun rights quite differently from many people today. The right to keep and bear arms was not a libertarian license for anyone to have any kind of ordinary firearm anywhere they wanted. Nor did the Second Amendment protect the right to revolt against a tyrannical government. The Second Amendment was about ensuring public safety, and nothing in its language was sought to prevent what would be seen today as quite burdensome forms of regulation. The founding era laws indicate why the First Amendment is not a good analogy to the Second. While there have always been laws restricting perjury and fraud by the spoken word, such speech was not sought to be part of the freedom of speech. The Second Amendment, by contrast, ambiguously recognized that the armed citizenry must be regulated and regulated well. This language must closely align with the Fourth Amendment, which protects the right to privacy, but also recognizes the authority of the government to conduct reasonable searches and seizures. The principle that reasonable regulations are consistent with the Second Amendment has been affirmed throughout American history. Ever since the first cases challenging gun control for violating the Second Amendment or similar provisions in state constitutions, courts have repeatedly held that reasonable gun laws, those that do not completely deny access to guns by law-abiding people, are constitutionally permissible. For 150 years, this was a settled law of the land until Heller. Heller, however, rejected the principle of reasonableness only in name, not in practice. The decision insisted that many types of gun control laws are presumptively lawful, indicating bans on possessing firearms by felons and the mentally ill, bans on concealed carry, bans on dangerous and unusual weapons, restrictions on guns in sensitive places like schools and government buildings and commercial sale restrictions. Nearly all gun control laws today fit within these exceptions. Importantly, these exceptions for modern gun gun law, unheard of in the Founding era, also show that lawmakers are not limited to the types of gun control in place at the time of the Second Amendment's ratification. In the years since Heller, the federal courts have upheld the overwhelming majority of gun control laws challenged under the Second Amendment. Bans on assault weapons have been consistently upheld, as have restrictions on gun magazines that held more than a minimal number for round of ammunitions. Bans on guns in national parks, post offices, bars, and college campuses also survived. This decision made clear that the lawmakers have right levy to restrict guns to promote public safety so long as the basic right of the law-abiding people to have a gun for self-defense is preserved. Remember, the biggest open question after Heller is whether the Second Amendment protects the right to carry guns in public. While every state allows public carry, some states restrict the right to people who can show a specific reason to have a gun on the street. To the extent these laws give local law enforcement unfettered discretion over who can carry, they are problematic. At the same time, however, many constitutional rights are far more limited in public than in the home. Parades can be required to have a permit, the police have broader powers to search pedestrians and motorists and private homes, and sexual intimacy in public places can be completely prohibited. The Supreme Court may yet decide that more stringent limits on gun control are required on the Second Amendment. Such a decision, however, would be contrary to the text, history, and tradition of the right to keep and bear arms.